Welcome to Guardians of Innovation, Patent and Trademark Law with Vincent LoTempio. Join us as we dive deep to help inventors and entrepreneurs secure and profit from their valuable ideas.
Hi, everybody. Welcome to Guardians of Innovation, Patent and Trademark Law with Vincent LoTempio. I'm Matt Skye. With extensive experience in patent and trademark law, Vincent helps inventors and corporations profit from and secure their valuable ideas. Vincent, thanks for joining us.
Hey, thanks for having me. I'm looking forward to doing this in the future with you.
Absolutely. Let's jump right in. So tell us about your journey to becoming an intellectual property attorney and what motivated you to specialize in IP.
Well, I'm not the atypical patent attorney out there. Most people started with a degree in some sort of science. I actually started with a degree in finance. And when I first got out of law school, I became an assistant district attorney. And after about 5 years into it, I basically said to myself, I don't want to be doing criminal law the rest of my life. I want people coming to me and saying, oh, it wasn't my marijuana. I was just holding it for my friend and trying to get them out of jail. And I wanted to do something, more interesting for me and more, better for just society as a whole. People trying to invent things, people trying to make the world a better place. And I literally had to reinvent myself.
So what challenges and rewards do you face when managing sizable corporate patent and trademark portfolios? I'm sure there's quite a few.
Yeah, I handle, I'm a smaller firm, right? So I'm not, you come to me, you're not looking for that big firm person, but I have a bunch of, $50 million to $100 million corporate clients. And I have the mother with the new baby bottle nipple and everything in between. So for the corporate clients, I put together like a corporate trademark and patent policy for them. We put together like a committee, and we call it the patent committee or the invention committee. And so a corporate client will have employees that come up with new ideas all the time. So I came up with this idea that we'll record everything they come up with as they go along. If we have to prove that they invented it while they were working for you, we'll have that. We put together like a hard drive just for ideas. And I came up with like questionnaires and disclosure documents. So even if the employee leaves the company, some other employee can just pick up and run from there. Or if the employee leaves the company and steals the idea, we can prove that they've had it. And then what we do is we meet every so often, once a month, once every other month, with research and development, the marketing, and the VP that's going to make the decisions. And the VP, and I tell independent inventors all the time, the VP always makes his decision based on return on investment. How can we invest this money getting the patent search, doing all this stuff and getting it up and going? Who's going to buy this product and what's going to be our return on investment? And that's really not my department. I always say, the inventor or the vice president is kind of like a general contractor building a house. You got to get 3 bids from the plumber, the electrician, the gas guy. I'm just the plumber. I'm like one part of the whole process. I'm the patent lawyer. My job is to try to protect it. Their job is to try to, not to try, but to manufacture, market, and distribute a product and then make a profit off of it. Because it doesn't make any sense if you get a patent and you just could hang it up on the wall if you can't make any money from it.
Yeah. So when you're doing the hypothetical plumbing portion, can you tell us more about the significance of intellectual property as a corporate asset and how you assist corporations in leveraging it for profit? That's kind of where you help people out here.
Yeah, so there's a lot of different angles to this, and it's hard to answer with one question. But first, you do the search to see if you can be the only person that has it, right? And if you are the only person you need to protect it, then a patent doesn't give you a right to make something. It gives you a right to stop others from making it. So you can go out and you could be the only person making it, and you have a little bit of a head start or a monopoly for a set number of years. Right now in the US, it's 20 years from the date that you file the application. So you get a head start. And, everybody recognizes Viagra. When it goes off patent, it becomes, this blue pill without the trademark name. So patents only last for a certain period of time. So we have to make that determination as to whether other people have it. And, when I first asked the question, I said, well, how do we do that type of research? I mean, certainly, you want to know like in the Army, they call it espionage. You want to know what the other side is doing. So you almost have to do that research and know what they have, and they're doing the same thing with you, and you're both trying to make the better mousetrap. And so keeping an eye on what the competition is doing is important.
How do you gauge that when two patents are quite close, but not that close? They're in the same vicinity. Maybe they could be arguably the same IP, but not.
Yeah, I mean, that's the question everybody asks, and everyone says, oh, patents aren't worth anything because if you just make it a little bit different, you're not covered. And that's really not true. I mean, the rule is that it has to be new. No one's ever done it before. It has to be useful. That's the utility of it. It has to work. And no one's ever come to me and said, I have this thing that doesn't work. So usually it's new. No one's done it exactly like it. And it's useful. Then it comes down to obvious improvement. And is it an obvious improvement of what you made, or is it not obvious, something that's inventive? And if somebody changes just one little thing, it doesn't necessarily change the whole thing. It just changes that part of it. So the question is, what did they change and how they did that? And a simple way that I use to describe that is, say you're the first caveman and you invented the table, and you have this. You're not eating off the rocks anymore, and you have a table. It's got a top, a bottom, and four legs coming out of the corners. And you get the patent on that. Now, somebody else makes a patent with a top, a bottom, and three legs out of the corners. Changes just a little bit different. Are they infringing? What do you think?
I would say no.
Yeah, and you're right. They're not infringing because they didn't have all the parts that you had. But we don't care if you make a table with three legs because it's not going to work. Who's going to buy a three-legged table, right? So what else? Not only we change it a little bit more. What happens if you make a top, a bottom, and four legs out of the bottom, but you add a pencil sharpener, a fourth leg in the middle, and you add a Pez dispenser on one of the legs? Are you infringing now?
This sounds like a completely different product at this point.
Yeah, but you still have the top, of the bottom, and the four legs, and it doesn't matter what you add to it. You could add a million things to it. You're still infringing. So that's the difference of whether they change something. If they change something significant and it doesn't work anymore, we don't care. If they add anything to it to make it different, we still don't care because they still are infringing on our table that has a top, a bottom, and four legs.
That's a really great analogy, actually. Very, very helpful way to kind of see it. So to that point, how do you centralize and streamline the management of a corporation's intellectual property? How do you defend and enforce, I guess, if you will, when you know you have that table, so to speak?
In my position as a smaller firm, I'm trying to undercut the big firms' prices, give you the same type of product, that or better product than these big firms are offering because they have all these associates that don't even take a personal interest in the person, where I'm more one-on-one. And like I said before in the previous question, with the big firms, I try to set up the patent committee and the patent policy with them up front so those issues don't happen down the road, and we're ready to resolve it. With infringement, that's more of a litigation thing. And what I do to get involved at first, if we believe there's an infringement, we'll send out the cease and desist letters and stop them from doing it. I don't know if you saw, I was on that national television show, $1 Million Genius on the History Channel, and we worked with the guy who invented the selfie stick. And Wayne Fromm, and how many people made the selfie stick? And you can see in the video in the show where he talks about, we didn't try to start a lawsuit with every single person in the world, all the Chinese and everything. We threatened them. We told them we were going to send, and we worked out deals where we cross-licensed it and let them just send us money. So we worked out deals. So there's every type of litigation, there's a different way to settle it. And most of them don't end up in lawsuits and trials. They end up with settlement. And that's where I come in. But if it gets to the litigation, I kind of take the back seat as far as being the litigator, more of a, consultant, because the litigators really aren't patent attorneys. They don't know the patent law, but they know the litigation, the ins and outs of the courtroom. And I don't know the ins and outs of the courtroom. So we work together as a team.
So would you say more of your day-to-day when it comes to streamlining and centralizing intellectual property, it's partnering with different companies and organizations and inventors rather than necessarily the threatening letters and all the sort of cliches we all imagine in our heads? Well,
yeah. I send those threatening letters out with all the legal mumbo jumbo in there, threatening, to take away their first child if they don't stop. But yeah, I'm more of a writer of the patents more of the
Right.
prosecutor. So you have the invention, you come to me, I do the research to see if that invention is going to be, has a chance of becoming patentable. There's no guarantees in any of this stuff. But, I call the patent search the stop the bleeding stage. If we find it and it doesn't look like you have a chance of getting it, let's not spend all this money going forward. At the end of the day, we still have to think about the ROI, the return on your investment. Are you going to be able to get this money back? I jokingly say to my clients, look, I just want to see you make 1 penny. And I don't mean selling one product for 1 penny. Just get every penny that you put into this back and make 1 penny profit. And then after that, everything is gravy. Let's just see if we can get to that point. And that's the first step. But, like I said, I have multi-million-dollar clients and the mothers with the baby bottle nipples. And you just never know which one is going to be that next selfie stick.
That's an amazing range, too, going from corporate to personal. So when you're working with a client, how do you evaluate an invention for feasibility, patentability, and then wide commercialization?
Yeah, I'm not, like I said before, I'm a lawyer. I'm just one step in the process. I'm not a developer. I'm not a manufacturer. I'm not a distribution channel, but I have connections with all these people. I've been doing it for 25 years, so I can make those introductions. There's a basic checklist of things that make something commercially viable. How much does it cost to manufacture? The set number is, nothing's set in stone, but the general number is you got to be able to produce it for 1 to 5, right? 20%. So everybody can get paid. So if you're going to sell it for $20, you got to be able to produce it for 4. So, and then everybody else. So there's like set parameters, you got to be able to ship it. So if it weighs 7,000 pounds, even if you can produce it for 4, how are you gonna make money off it? So there's a whole set of parameters to whether its commercialization is okay. But at the end of the day, people got to like it and buy it, right? And you're only as strong as your weakest link. And I always say, if you had a time machine and you went back to 1976 and I said, here's a great idea that made millions of dollars. It was called the pet rock. You could sell a rock in a box to people and say, you don't have to wash it. You have to get somebody to look after it when you go on vacation. This is going to be the best pet you ever got. Even if you put that guy in a time machine and put him back, could he catch lightning in a bottle and do it again? And if that guy came into my office today, I'd throw him out and say he was crazy and say, get out of my office. And he'd go out and sell 8 million of them. So I say, I never try to discourage or encourage anybody because you never know what is going to be that next great product that's going to make millions of dollars. But at the end of the day, it's not like a lottery ticket where you just show it to somebody and all of a sudden you start making money. There's a lot of hard work and elbow grease that goes into it.
Oh, that's interesting. Very great example. What are the key points you emphasize to corporate employees when teaching them about identifying and protecting intellectual property?
I wrote this book, or co-author of a book for fundamentals for scientists and engineers. And I think the guy that wrote the original version of it, he was my mentor, Arthur Cookfair. He's passed along. He's probably, if he was still alive, be close to 100 right now. But he was my first mentor in patent law. And when they came up with all the new rules in 2013, they wanted to update it. And he asked me if I would do it because he wasn't up to doing it. And I would, write the new chapters and, the new laws and get it all up to date to the current laws. And what he gave me too was a course that he teaches for engineers. And I do that for my corporate clients as part of it, where we go in and we just talk to employees and help them understand what is, patentable subject matter. Because a lot of them think, oh, this is no big deal because they're experts on it, and to them it didn't feel like it was a big deal. But it very likely could be intellectual property. And I think a lot of the intellectual property in the corporate environment gets lost because they don't, keep track of it. And like I said in the previous question, I came up with a questionnaire that every new idea that they come with, they record and then we review and we go over it. But part of it is understanding what is patentable. And I kind of gave you that description before. There's 3 words of art. They're not things that I'm creating. It's novelty, utility, and obviousness. It has to be new, useful, and non-obvious. And like I said before, new is always there. If I told everybody on the planet, hey, make me that table with the top, a bottom, and 4 legs, and let's go look at them next Tuesday, there would be 18 billion or 8 billion people on the planet, 8 billion different tables, different sizes, shapes, colors. None of them would be patentable because there would just be a table, but none of them would be the same. They'd all be different somehow. So I guess that's the biggest thing that they have to understand, that what you created has some criticality that improves it, makes it harder, stronger, faster, hold more weight, or whatever it does, slower, and that makes it an improvement. And then the question is whether or not it's an obvious thing.
Now, you're mentioning this is your book, Patent Fundamentals for Scientists and Engineers. Is there one area where you see people have the biggest misconceptions about inventions and patents?
Yeah. Like I said, those are the two biggest ones that we kind of already discussed. They think that if you just change something very small, that you're not going to be protected. And the other one is just identifying what it is, and to understand that what you created can be patentable. And again, what I said before is it all comes down to the ROI. I mean, we can protect something. If you're not going to make any money of it, it's not worth it. So, you're only as strong as your weakest link. And if all these parts don't all fall into place, then it's not going to work. It's the end result not going to work. So you need to start with a strong foundation when you're building that house. The general contractor, you can get 3 bids from the plumber, the electrician, and the painter. But if the guy who put your foundation in the house gave you the lowest bid, but the whole house falls down, what good is it? So at the end of the day, you got to make sure each one of these chains in the links are taken care of. And of course, if right from the get-go, somebody invents something and doesn't even realize that they invented it and never tells anybody about it, well, that first link isn't even there. I mean, so how is it ever going to get to the point where you're going to make it a commercial success?
How do you deal with that when people have an invention and they're scared to share it?
That's always the first question when someone calls me on the phone. Don't we need to sign an NDA? Well, yeah. I mean, when you're dealing with like a manufacturer or somebody, there's no fiduciary duty. A fiduciary duty is between a lawyer and a client, a priest, penitent, or a doctor, patient, professional responsibility. So the rules of professional responsibility require that I keep everything secret. And I've been doing this for 25 years. I tell them, if I've been stealing people's ideas, I'd be in jail a long time ago. But the fact that you're hiring me, if you don't trust me, and you think that you need me to do that, then you probably shouldn't work with me individually. But if you go out and you're trying to market this to somebody that you don't know, doesn't have any kind of duty to you to keep it secret, then you better sign that NDA. You better get that patent up front. But my job is to work zealously, as hard as I can, to protect your idea as the patent lawyer. So hopefully, we can build that relationship and people can see that I'm the person that's there to help them, not to hurt them. I coached ice hockey for 8th graders to like sophomores and juniors. And I tell them, there's 3 things you need to be in life. And this is the same thing I tell inventors. You need to be street smart, you need to be book smart, and you need to network. And the reason why you have to be book smart, you have to know all these rules. You have to know how much it costs to produce a product. You have to know what the transportation of it's going to cost. All the little elements, those are book smarts that you can't learn unless you'll learn it. It's not innate. Books, or the street smart part of it, is what we're just talking about. You got to have the gut instinct to work with the right people. Avoid the bully. Avoid that person that's going to steal your idea. That's not going to deliver what they say they're going to deliver. And then you have to network. You have to meet as many people in the industry you never know which person's going to help you or you're going to help them down the road. And that's what's going to make the difference between you selling this product or not selling it. So book smart, street smart, networking.
So you're a frequent guest columnist and you cover intellectual property law and trends. How do you determine which areas to cover?
So I use Google Alerts to be aware of what's in the industry. And you know what? If you see the same thing coming back over and over, that's a trend, right? That's something that's hot. And I'll try to write about that. Like the most recent thing I wrote was AI. That's kind of, everyone's talking about AI right now in writing and stuff. And in fact, I asked the AI to write the article and then to see what the difference between my article and that article was. And today I just saw in the news that the Trademark Office refused to register Little Trump or Trump Little or something like that because he's a real person, didn't give permission to that, where the other side argued that it's just a political view and that it's freedom of speech. but the trademark office rejected it. So I imagine that's something that people will be talking about today. So you know how news is today, and it's so transient, and everybody has to consume so much. It's not like when I was a kid, we just had 3 stations, and you sat and watched Walter Cronkite, and if he talked about the pet rock, you went out and bought one. I call it drinking from the fire hydrant. You can't stick your whole head in there. You just got to take little sips, and eventually you fill up the bucket.
Makes a lot of sense and very true on the media. I think the TV used to just turn off at a certain time too, right? There was like an evening end.
Yeah, there would be like the picture of and they sing the national anthem, and it would just go beep, for 5 hours.
There's no turning it off now.
You'd have a test pattern. That's what I was thinking about. Test pattern.
So as we wrap up, and sort of our last question for this podcast, I want to ask you, what kind of advice would you give aspiring intellectual property attorneys, and how can they make the biggest impact in this field? I
definitely think the best thing you should do is do an internship first before you decide to become a patent attorney, right? I mean, I always say the secret of life is to finding something you love to do and getting somebody to pay you to do it, right? And that if you're not going to enjoy it, and you're not going to be able to feel like you're going to come to work today and this is going to be exciting stuff for you, then don't do it. Do something else. I say the same thing to the kids that come to play ice hockey. I say, if this is a job for you, then don't come. You got to come here and have fun. My best part of my job is this one-on-one type of just talking with you today and just, getting to know the person, and it's tough as an attorney writing all this legal mumbo jumbo, and it's like you're writing a term paper every day of your life. So you got to be prepared to be able to write, to be able to describe. They say writers don't write, they just rewrite and rewrite and rewrite. And that's what you're going to do. And so you better be prepared to do that heavy load part of it, the hard work and elbow grease. But if the underlying part of not wanting to, make society a better place, make the world a better place by protecting people's ideas and encouraging people to come up with better ideas to make our lives better. Because essentially that's what it's all about, right? We're making our lives a little easier, better, improving technology, then do something else.
I love that point, both to enjoying and loving what you do and also just adding some value to this world. Everybody, thank you so much for tuning in to Guardians of Innovation. For more information or to connect with Vincent LoTempio, find him on social media. Vinny, thanks for joining us.
Thank you. I had a great time. I enjoyed this time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.